So this is now the Q&A. Now, one thing I just wanted to cover with everyone real quickly is I was telling a story about a guy that built this incredible number of hours when after he didn't make partner. And what happened, just to give you an idea of how important billable hours are, is he ended up, after that happened, he ended up with being able to have to become a partner in the law firm by billing so many hours like he did. So just showing everyone kind of the importance of billable hours and how incredibly important that is for a law firm. So I'm going to go to Q&A right now. I apologize that I had that mix up with the power here, and not something that normally happens here, but I did have a power failure. So you can read one quick second. Okay, so this next question, there's not a lot of questions. I do have a little bit of it. Actually, there are a few questions, a little bit of a time crunch here, but the first question is, in my firm, there's been some debate about whether we should adopt alternative fee agreements instead of relying solely on billable hours. I'm curious to know your thoughts on the pros and cons of each approach. Have you seen any successful examples of firms transitioning away from billable hours? And if so, what factors contributed to their success? How can I present the idea of alternative fee agreements arrangements to my partners in a way that encourages productive discussion and decision making? Honestly, as an associate, it's not really your role to come in and talk to your law firm about alternative fee agreements. So that's not really your role. Partners are in charge of however they charge their clients. It's not something that you really should be trying to discuss with your firm. You can certainly bring it up, but ultimately it's the partners that have control over how they bill their clients. Your job as an associate is really just to be a worker and do the work. As a solo practitioner, I often find myself juggling multiple cases simultaneously, which can make it challenging to accurately track my billable hours. Do you have any tips for maintaining organized records of my time without feeling overwhelmed? More about how can I ensure I'm allocating enough time to each case while still maintaining a healthy work-life balance? I'd appreciate any advice on establishing effective time management practices tailored to the needs and demands of my solo practitioner. Okay, so it's not really you're as a solo practitioner, it's really your role to figure out how you're going to bill clients for your time. It's not really something that I can help you with. I don't think it's, in terms of your organized records, I don't know. That's really going to be your decision in terms of what clients are willing to pay. But I don't think that's something that I can really help you with in terms of your work-life balance. You have to take clients and work on cases the way you want. Okay, I've recently had a situation where a potential client seemed interested in my services, but they ended up going with a more senior attorney at the firm. How can I compete with more established suppliers within the firm to attract clients and build my own book of business? It's just hard when you're losing on opportunities, especially when I know I can handle the work. I don't know what happened there, but you have to, if you're bringing in work and you're competing with a partner, typically, if the partner's the one that gets credit for it, then you have to do a better job of making sure you get credit. So it's actually an interesting statement that you made. What happens to a lot of associates and firms is they bring in clients, but then a partner will end up taking credit for it. That's just something that happens. So you need to figure out a way to get credit. Sometimes in firms, you can't get credit. So there's certain firms where if the partner had contact with the client at any time in the past before you, then they're more likely to get credit for the work than you and I mean for the client. So you have to either be in a firm where you're going to get credit or figure out the ways to get credit for bringing in other clients. So it's a good question. It does happen to a lot of attorneys where they get in a position where partners are taking credit and getting the clients to you. I've seen that happen to people on a lot of occasions. You just need to become savvy and realize how to make sure that you're getting credit for the client that you bring in. I've heard about the importance of tracking non-billable hours development and activities, but I'm not sure where to start. Can you recommend any specific tools or methods for keeping track of networking events, client meetings, and other activities that contribute to building a book of business? I want to demonstrate my value to the firm beyond just billable hours. As I said in this presentation, you're welcome to keep track of all these types of events for business development activities and so forth. But Ultimately, what's most important to the firm is you being able to actually convert those non-billable hours into clients. A lot of attorneys will write down business development activities and other things, but they're not necessarily going to be able to get, they're not always going to get credit for bringing in for that type of work. It's not leading, unless it leads to money, people aren't really going to care. So you can certainly, one thing that I noticed, a very successful attorney that I know, and he's got a huge book of business right now, like 30 million. What he did was his associate was he would go and he would bill his 2,000 hours a year at the firm, but then he would spend another 2,000 hours going out and developing clients, not getting credit for that. But over time, he was able to bring in a significant book of business. So you have to decide how you're going to use your time here. And if you do not billable work, you can certainly write it down, but it's only going to matter if it converts to the clients. Okay. I often find myself torn between prioritizing billable work and investing time in activities that could lead to future business opportunities. How can I strike the right balance between meeting short-term billable hour requirements of focusing on long-term career growth? It feels like something I'm stuck in a cycle of constantly chasing billable hours without progress towards partnership. Okay, so I think it's a similar answer to the question I answered before. You need to be able to run your life, and so you can be bringing in business and also doing the work. If you are billing the minimum of what a firm requires or a little bit over the minimum, then you should also be doing business development activities as well. You need to make it part of your life. You need to run your life and your career in a way that also develops business. So that means going out and finding potential clients, entertaining them, doing whatever you can to bring in business while also doing the work that's required for you in your job. And if you're converting that time into clients, that's gonna lead to something. I've been in my firm a couple of years now, and I've noticed a discrepancy in how billable hours are allocated among associates. How can I ensure that my workload is balanced effectively to optimize my productivity without burning out? Well, as a junior associate and as a mid-level associate, especially, you're going to be judged by how many hours you bill. So that's just important. It depends on the firm you're at, and you may burn out, but you need to figure out if that's what you want to do and do your best to bill as many hours as you can. And if you feel like that's not something that you want to do, then you need to do something else. One thing I would talk about when people talk about burning out, people that burn out often aren't enjoying the work that they're doing. You should really try to make sure you're enjoying. If you enjoy litigation, that you really enjoy it. If you don't, then you should maybe be doing something else that with your time or different type of litigation. It's just what it is when you're working on in a larger law firm. Okay, in some cases, I've had clients request meetings or consultations over lunch, which typically extends beyond the typical billable hours. How can I approach these situations tactfully to ensure I'm not undervaluing my time while also meeting the client's needs? Are there ways to communicate boundaries effectively without jeopardizing the client relationship? Lunches, dinners, all that sort of thing are very important for developing clients. You don't obviously need to bill for all that time, but it's a relationship business. You should never think of spending time with clients or potential clients as something that's bad, because it will lead often, obviously, hopefully, to more billable hours in the future. Last question. This webinar, by the way, and this is not the most interesting one that I've done. I think that for a lot of people, billable hours it's not the most interesting topic, and I will definitely do a more interesting topic next week. And this is the final question, but this particular webinar is a topic that people need to understand when you're going into the practice of law, because it does determine how successful you're going to be, and a lot of people don't understand it. Someone considering a transition to a contract attorney role, I'm concerned about the potential long-term implications of my career trajectory. How do hiring managers and partners perceive contract attorneys in terms of advancement opportunities when the firm would transition to other roles? Are there certain strategies or experience that can enhance the marketability of contract attorneys for future career aspirations? When you make a decision to become a contract attorney, essentially what you're saying is that you want to be someone that was doing work for others and getting paid a certain way where there's no expectation of being a partner, and you're just basically hiring yourself out as someone to do the work. Contract attorneys are not, it's not a good position in a lot of respects. And this is actually a very good question about being a contract attorney. The reason it's a dangerous decision is because once you're a contract attorney, the odds of you becoming a regular attorney within any law firm are very slim, because it's not perceived as good of a role. I've seen people that went to Yale Law School become contract attorneys within the firms. And the problem being a contract attorney is if the work runs out, then they're going to let you go and give it to associates. A contract attorney does not look good in your resume because it shows that you don't have the ambition often, or don't want to be a regular associate with those expectations. You want to, basically run your life and career doing as little work, working in a role where you're just paid for your time and you're not there for advancement and so forth. And that's a dangerous decision to make. And your long-term career directories are basically, you're showing future employers that you either weren't good enough to be hired as an associate or whatever it was, or that wasn't your long-term interest. So it's very difficult to be marketable as a contract attorney. You may have to move between firms. Another danger of being a contract attorney is that the work you do is typically not going to be as sophisticated as the work that's given to regular attorneys. You'll be doing work often that other people don't want to do, that other associates don't want to do. It's maybe more busy work, and it's difficult. So what do you do to transition to other roles? You basically will try to find a firm that's willing to hire a contract attorney as a permanent associate or another role, but it's not easy. So you're becoming a contract attorney, you're often avoiding the expectations that may be there for a typical associate, but your advancement opportunities are very slim, and it's scary now. I mean, if you make that decision, it does have long-term implications, because your resume shows you're a contract attorney at the firm, which makes it's not the same as being a regular attorney. Now, there are people that are able to stay contract attorneys inside of law firms for a long time. Some big law firms have people that might have been a contract attorney there for 20, 30 years, but often not that long, more like 5 or 6 at the longest. But it's difficult. You don't have a lot of career, you don't have a lot of job security. It's also, to bring in business as a contract attorney is almost unheard of. It is very limiting. Same thing for being a staff attorney. You need to be very careful, because your marketability is going to decrease. Your advancement opportunities are very slim, as well as your employment security. So those are some of the things I would say about that. So thank you for being on this webinar. This was not the most exciting of topics. I will definitely admit that. Next week's webinar will be much better. I appreciate everyone staying with me with power failure, and I will be back next week. So thank you for being on this webinar.